So, as with the previous panel, I will be taking comments from either the online audience or the real-time audience via Slido. Slido.com, ULR22 is the conference number. So enter those anytime. We're going to have about 10 minutes of commentary and observations from each of the panelists, and that'll leave us about 20 minutes for question and answer and discussion. The program is wrong, as you probably figured out. This panel will end at 5 till at 4:55. And we've got Mark Glick will make some final concluding remarks. But yeah, there's no need for that 15-minute gap between these two things. That's just a typo. So with that, why don't I turn it over to...
Thank you, Jorge. And let me thank Utah Law and the organizers for inviting me to join you here today. Really delighted to be here and delighted to be here with my fellow panelists. So I'd like to focus my remarks on the intersection of intellectual property and antitrust in the standard setting context. And this was an area that I focused on during my time the Obama administration and at the FTC. So particular area that's close to my heart. And I thought that it would make sense to talk about how both agencies, the FTC mainly, but also DOJ, approached issues at this intersection. And then I'll lead up to where things are right now. And I think my remarks will also be, I think, a good stage setting for some comments that I know that Michael will be making. So I'll start by saying that at the core of the way that the antitrust agencies think about IP and antitrust, they think about these as being complementary bodies of law, both of which promote competition and, if it's still permissible to say, the consumer welfare standard. But at the same time, and I'll also highlight that in the standard setting arena in particular, antitrust law absolutely recognizes the pro-competitive benefits of collaborative standards development and recognizes the importance, particularly in the ICT sector. But at the same time, we have to recognize that standard setting can create the risk of opportunistic conduct, and there are very legitimate antitrust concerns that can arise if members use the standard setting process as a means of harming rivals or otherwise seeking to gain an advantage in the marketplace. And one area of concern during the Obama administration, but even prior to that, is behavior known as patent holdup. Patents that cover technology that's been adopted into a standard can empower their owners to demand higher royalty rates and other more favorable licensing terms than they would have otherwise been able to demand before that technology was incorporated into a standard and the standard is adopted. So there is this concern about the potential risk of patent holdup and the fact that that patent holdup can then lead to the extraction of higher undue leverage and higher royalty rates. Now, in the early 2000s, actually, let me back up and say that to address this risk, standard setting organizations often seek voluntary commitments from patent holders to license their standard essential patents on fair, reasonable, and non-discriminatory terms, or FRAN terms. And in the early 2000s, the antitrust agencies were focusing in particular on the disclosure aspect of standard setting intellectual property rights policies. And as an example, in a number of cases, the FTC challenged the conduct of SEP holders, where the agency alleged that the SEP holder failed to disclose essential patents during the standard setting process to avoid having to make a FRAND commitment. And the concern there, of course, was that the failure to disclose ownership of essential patents could skew the outcome of the standard setting process, depriving a standard setting organization of the opportunity to select an alternative strategy and an alternative technology. And one of the most more high profile cases of that era was the Rambus case that was brought by the FTC. The FTC issued a commission decision finding that there had been a violation of Section 2 and Section 5 of the FTC Act. Unfortunately, that case was reversed by the DC Circuit in an opinion that I think is flawed, but just highlighting challenges that the agencies have when it comes to bringing Section 2 cases. During the Obama administration, moving on from these disclosure type cases, there was also great attention played by the antitrust agencies on licensing activities of SEP holders in light of brand commitments that have been made to standard setting organizations. So as one example, in 2013, the FTC brought an action against Google and Motorola Mobility, alleging that Motorola Mobility and then later Google, after it had acquired MMI, evaded brand commitments to license patents essential to the implementation of various standards by seeking or threatening to seek injunctions and exclusion orders from the US ITC against willing licensees. The FTC alleged that doing this against a willing licensee constituted a breach of the SEP owner's brand licensing commitments, and that it also constituted an unfair method of competition in violation of Section 5 of the FTC Act. To resolve the anti-competitive concerns, the FTC required Google to enter into a consent order that prevented it from seeking or threatening to seek an injunction against implementers who were willing to accept a license on brand terms. And it also required Google to resolve any disputes over licensing terms before a neutral third party before seeking an injunction. As a side note, I'll comment here that there's some debate about whether Section 2 reaches this particular conduct, because at this point in time, a SEP holder would have, any market power acquired via the standard setting process would have already transpired, and the conduct of having undue leverage and perhaps extracting higher than reasonable royalties is it in maintenance of a monopoly. So there is this debate about whether Section 2 reaches that conduct. Here, I felt that this was an area where Section 5 of the FTC Act, which does extend more broadly than the Sherman Act, this is, to me, a prime area where Section 5 can really be useful. So it's what's referred to as the standalone Section 5 jurisdiction. At the same time, DOJ wasn't necessarily bringing enforcement actions in this area, but they expressed very similar concerns and issued a joint policy statement with the Patent and Trademark Office, expressing concern about the issue of patent holdup and noting concerns about the undue leverage that could be placed on negotiations with regard to licensing terms in the context of seeking an injunction or an exclusion order when you have a willing licensee. Now, critics of this approach argued that the antitrust agencies were really helping and tipping and skewing, distorting things in favor of implementers and unduly penalizing patent owners. In my personal view, there are definitely solutions that patent owners can have when they're dealing with licensees who are dragging their heels or otherwise not willing to enter into a brand license. And the core issue is that in the face of a intransigent licensee, there certainly should be the option of obtaining an injunction, but in the face of a willing licensee, a patent holder shouldn't be able to extract undue leverage in that particular context. Let me shift over to what transpired during the Trump administration. So when Assistant Attorney General Macon Del Rahim came into his position at DOJ, he had a very strong view in favor of patent owners and felt that antitrust really had no place in this conversation at all. And he really did a complete 180, reversed course, withdrew this 2013 policy statement that had been issued by the earlier administration, DOJ and PTO, and took the position that SEP holders should be free to pursue all remedies, and that the bigger concern was not the issue of patent holdup, but rather what's referred to as patent holdout, and that it was inappropriate for antitrust to be intervening in favor of implementers. And in his view, any evasion of FRAND commitments was a mere contract issue rather than an antitrust issue. I'll note that DOJ was being, under Macon's leadership, was being very active, and not only had withdrawn that statement, but the DOJ also submitted various statements of interest and intervened in various lawsuits, private lawsuits, and also a lawsuit that the FCC had filed against Qualcomm, challenging Qualcomm's licensing practices, a rather public point of disagreement between the two agencies. Ultimately, the FTC, which had prevailed in the Qualcomm case at the trial court level, that decision ended up being reversed by the Ninth Circuit, and the Ninth Circuit adopted a lot of the arguments that Macon, Del Rahim, among others, had been making about taking the position effectively that any evasion of FRAND commitments was really something properly dealt by contract and not by antitrust. So fast forward to the Biden administration. Last year, when President Biden issued his executive order on competition, one of the issues that he directed DOJ and the PTO to look into was to evaluate a statement that had been issued under the Trump administration, under AAG Del Rahim, his 2019 policy statement that embodied his views. President Biden directed the agency to take a look at that and evaluate whether it was appropriate to withdraw that statement. In December of last year, that's exactly what the DOJ did. And DOJ, alongside the PTO and NIST, sought public comment, asking whether it would be appropriate to withdraw the 2019 statement. They also put out a draft statement themselves, which largely returned to the position of the Obama administration, raising concerns again about the remedies available to SEP owners who had made FRAND commitments. But the statement did also give something of a nod to critics who raised concerns about the behavior and opportunistic behavior of implementers. And I think in trying to hit something of a middle ground, ultimately the feedback that the public comments that the agencies received was not particularly well received overall. And in this past June, the agencies decided to formally withdraw the 2019 statement, but they did not move forward to adopt the draft statement that had been issued. And the current state of affairs is there was a statement by DOJ that basically just simply said, we think antitrust should play a role here, but we will be looking at the conduct of both patent owners and implementers and making a determination about whether there might be anti-competitive conduct. So there's a role here to be played, but we're going to be looking at both sides, and we'll be determining on a case-by-case basis whether there's anything that ought to be done. Leaves a lot to be desired. At least I think it certainly was a step in the right direction to formally reverse the position that AAG Del Rahim had taken and to withdraw that 2019 statement. But my hope is that there will be some additional reinvigoration of the role that antitrust plays in this arena. And I think we have to stay tuned to see what else will come.
Okay, great. Thank you. Michael.
Great. Thank you. Thank you so much for having me. Thank you all for sticking around until the end. And so I will pick up on a lot of what Edith said in talking in my first half of comments about standard essential patents and a lot of the huge unforced errors that were made in the last administration. And then the second half, I'll talk about pharma. So in the last administration, Macon Delrahim came into power with a position that was far out of the mainstream and one that really put patents above all else and said there could be no antitrust problem. So when you think about standard essential patents, you think about the way that antitrust can play a role, the way that we heard about patents could be used to hold up an industry. And so Mr. Delrahim came into power with tons of speeches and policy proclamations and everything else. And they relied on 6 basic principles. First, that a patent is a property right, which gives you a right to exclude. Second, that a patent gives you the right to an injunction. Third, that there's no antitrust problem at all. Fourth, that hold out among licensees is worse than hold up. Fifth, that innovation is crucial, so we can't limit the patent. And sixth, that compulsory licensing is bad. Mr. Delrahim repeated these 6 in so many of the things that he did, but each of the 6 was fundamentally flawed. So if you think about the first, property is not absolute. Early in my career, when I had time to write 160-page law review articles and think about 50 limits in property law, I learned that property is not absolute. As someone who teaches property law, we spend tons of time talking about limits, things like adverse possession and eminent domain and easements. If you have property, you don't have an absolute right to exclude others from your property. And so it's no such thing to have an unlimited property. Second, there's no such thing as an automatic injunction. I mean, that's what the eBay case said. The Supreme Court in eBay was crystal clear that you don't automatically get an injunction. In many cases, especially these cases, damages would be an appropriate remedy. Third, antitrust could play a role here. Yes, patent law does. Yes, contract law does. But in certain cases, you can maintain or obtain monopoly power, for example, by breaching a promise that you made and then getting monopoly power as a result. Fourth, in terms of holdout, if a particular licensee doesn't accept a license, that's not an antitrust problem. That's a problem for patent law. If you have collusive conduct, that's something else. But again, individual licensee determinations are not an antitrust problem. Fifth, in terms of innovation, it's really frustrating when you focus just on the initial generation of innovation, say, we can't touch patents because that's the end of the world. Innovation is cumulative in nature. And it's not just about that initial determination, but it's about the follow-on innovation as well. And this is the trade-off between Schumpeter and Lara that goes back decades, in which there have been dozens, if not hundreds, of articles that have been written in the economic literature, not providing one simple answer for the market structure most conducive for innovation. And sixth, compulsory licensing. This is not compulsory licensing. That is when the government forces someone to license against their wishes. Here, in contrast, the patent holder is choosing to adopt what's called a FRAND promise, fair, reasonable, and non-discriminatory, which limits the royalties obtained because the volume is so much higher. You're incorporated into the standard. So in short, Mr. Delrahim based all of what he did on 6 principles, and I think all of those are wrong. Then you see the effect that it had. So it not only was in speeches, it not only was in amicus briefs, but it was in things like withdrawing helpful letters. So the IEEE is a standards organization, and they received a business review letter in 2015 that basically said it's good to provide clarity when it makes clear that you don't automatically get an injunction after making a FRAND promise. When there's a focus on a reasonable rate, that seems to make sense. Nonetheless, in 2020, Mr. Delrahim withdrew this and said that there's no concern with holdup and IP and patents give you an exclusive right, so therefore we were going to withdraw this letter. Thankfully, in April of 2021, acting AAG powers moved this to a page, the letter, for like comments of states and other organizations where it's not really worth as much, and that was a beneficial development. A second example that was concerning involves the Avanci patent pool. So this is a patent pool for the automobile industry dealing with 5G technology. And it was really concerning when Mr. Delrahim issued this letter For starters, it doesn't seem to satisfy the non-discriminatory element of FRAND when you only say that a certain level of the distribution chain, the manufacturers, are the only ones who can get the patent as opposed to the component manufacturers. And second, when you say that we are going to reimburse litigation costs, and by the way, that could lead to more litigation, but so be it, that is a problem. And Alex Moss and I submitted a letter to AAG Cantor earlier this week in which we asked Mr. Cantor to reassess this patent pool, to withdraw the letter or relegate to another part of the website, because when you look at this reimbursement of litigation costs, what it has done is it has given free rein to patent trolls to file tons of lawsuits. So that's what we have. We have lawsuits by Optus, Sysvel, Nokia, Unwired Planet. The Conversant CEO said to sue and push into a pool license is hugely beneficial. In other words, Avanci is made up in part of patent trolls. Patent trolls file lawsuits, and it's easier to settle the lawsuit and take the patent pool, take the package that's in the patent pool, rather than fighting in court for years. That is really concerning. As 5G technology goes beyond automobiles to the Internet of Things, this could go everywhere. And so that's why I'm very concerned about this letter. Finally, the 2013 statement that we heard about before, the 2013 statement of the PTO and DOJ was incredibly balanced. It provided all sorts of places where injunctions were allowed. And in fact, the Federal Circuit, which is no stranger to weak patent rights, the Federal Circuit relied on the 2013 statement in explaining why injunctions were okay. The 2019 statement was not very reasonable or supported. I, too, am thrilled that the 2019 statement is gone, but I wish that something was put in its place to show that patent holdup actually still is a thing. So the first half of my talk was that there was a lot of harm that was done in the last administration when it came to standard essential patents, and we're starting to reverse that harm. The second part of my talk will perhaps be a little more positive in focusing on the pharmaceutical industry and all the good that the Federal Trade Commission has done. The agencies divide up who has what industry. The FTC has focused on the pharmaceutical industry, and so that's why my comments will focus on the FTC. Big picture here is that drug prices are too high. There are many reasons why, but antitrust can play a crucial role in lowering drug prices. And the good news here is that we don't have to worry about innovation. And so a lot of times you hear from pharma that this is the end of the world and innovation is going to dry up. It's not. And every time going back to the 1960s that Congress considers legislation on patent or antitrust, they say it's the end of the world. There's going to be no more innovation. But it's like the boy who cried wolf. You do it every single time, and it loses some credibility. And so the first thing I'll focus on here is pay-for-delay settlements. Brand companies and generics settle patent litigation all the time. Most of that is fine because it's settled based on the strength of the patent. Sometimes it's not fine because the generic stays out of the market for a longer period of time because it's being paid to stay off the market beyond what you would expect based on the strength of the patent. So from 2005 to 2012, all of the appellate courts said this was fine. Fell within the scope of the patent. It was a settlement. We'll presume the patents are valid. In 2013, the Supreme Court, in a case called FTC v. Activists, said that this could violate antitrust law. It could have anti-competitive effects. One of the most important decisions in the past generation, and the one that has led to a dramatic decline in concerning pay-for-delay settlements. So where are we now? Well, the FTC has brought crucial litigation in trying to continue the path of robust antitrust enforcement. I'd say the most important case is the Impacts case that was brought as an administrative matter and then was upheld by 3-0 by the 11th, by the Fifth Circuit, And so in this case, the brand company Endo paid the generic Impacts to delay entry on a drug that treated pain, an opioid that treated pain. And there were various forms of payment. So for example, there was a no authorized generic deal that was very valuable to the generic because the brand said it would not compete on the market. That was one form of payment. Another form of payment came from the brand company switching the market from one version of a drug to the other, which triggered the generic's ability to get $100 million for that. As payment gets more and more nuanced, the FTC will continue to play a crucial role in making sure that the obscure places in which the drug companies are hiding payment are not able to get away with something that is really concerning. And so that was one example. Another example involved Abbott and Teva, where the generic underpaid for the brand product. That's another way in which you can hide payment. And the third example is a recent case also involving Endo and Impacts. And in this case, because the brand version was withdrawn from the market, we're talking about a generic monopoly. And the district court in DC failed to recognize it. It said that the brand firm had a valid license and a right to exclude. That is completely at odds with what the Supreme Court said in Activist. In Activist, the scope of the patent test was eliminated because antitrust does have a role to play within the scope of the patent. Nonetheless, not every district court judge gets it right. This is an example of a court getting it wrong. Nonetheless, it says a lot about the state of our judiciary that I worry about what the appellate court would do, and I don't want this going anywhere near the Supreme Court, given that we still have activists on the books for now. It's a very different court than the court in 2013, and so it's unclear where we stand with that. Finally, two other types of anti-competitive conduct I'll mention quickly. One is product hopping. Sometimes a brand company will switch from one version of a drug to another just to delay entry. Sometimes the reformulations are fine. Sometimes there's literally no reason at all other than keeping the generic off the market. So for example, you'll switch from a capsule to a tablet or switch the dosage. Every time the brand changes the drug slightly, the generic has to go back to the drawing board and has to reformulate the product, get FDA approval, be subject to patent litigation and maybe a 30-month stay. It can't be substituted at the pharmacy counter because it has to be equivalent, and these small changes are enough to take it out of the realm of equivalence. And so these are examples of anti-competitive product hops. And one example of the FTC here is a $50 million settlement involving the opioid addiction treating Suboxone, which was switched from a tablet to a film. The tablet was safe, the film was not safe. Nonetheless, the manufacturer said the tablet's not safe, even as kids are putting the film in their mouths and not able to spit it out. I mean, the gall of switching from a drug that was a very profitable drug for you and then turning around and saying, oh, by the way, it's not safe. I mean, just it's galling. And so that's an example of product hopping that is very concerning. And then the final example I'll give is citizen petitions. Citizen petitions are meant to raise legitimate concerns with the FDA. I've done empirical research on this and found that nearly all of them are done to delay generic entry. The FDA denies more than 90% of these. More than 90% are filed by brand firms, not by citizens. And the examples are really concerning in terms of timing, where with the EpiPen, they knew about the concern years before they actually filed the petition. With multiple petitions, like dozens of petitions, all on the same conduct, with last-minute petitions right before the patent's about to expire, and with repeated petitions continuing to raise the same concerns, which the FDA can't get rid of on their face because it's 50 pages of legalese and scientific jargon, and each day in which the generic is not on the market is a day of more monopoly profits for the brand firm. So in short, there still is a crucial role to play for citizen petitions, product hopping, and pay-for-delay settlements, not to mention other forms of anti-competitive conduct in the pharmaceutical industry. And because the industry has so much to gain from delaying generic entry, and because they have so much to gain by making matters obscure and throwing up all sorts of complication, there's a crucial role for the FTC to continue to play. Thank you.
Two preliminary comments. Well, three. First, I'm not a lawyer. and I'm going to be arguing about a law. So you can take that for what it's worth, but I hope economics provides some insights in that. Second, I want to talk about standard essential patents. The Fran Declaration is a statement that the patent holder is willing to surrender exclusive use, and I think we ought to take it at that. And I'm going to argue in other cases that's not true. And third, I'm undoubtedly the only person in this room or in this conference who's going to argue for more market power, not less market power. So that's the forewarning here. So a trial ends. Let's suppose the plaintiff has prevailed. The asserted patents are valid. The defendant is assessed damages for past infringement based on a combination of estimates of profits that the plaintiff actually lost and/or a reasonable royalty applied to a measure of the defendant's actual sales. But if the patents haven't expired, the issues that triggered the litigation remain partially or fully unresolved. Specifically, the defendant's products incorporated the patented technology. However, but for the infringement, the plaintiff would have had at the date of trial and beyond an exclusive right to the patented invention. What's the court to do? Even though courts frequently face this general scenario at the end of patent litigation, and they always have to do something, of course, there appears to have been minimal effort to frame the options available to courts in terms of their effects on the incentives with regard to innovation by future potential plaintiffs and infringement by future potential infringers. A starting point for the post-trial remedies is to note that the plaintiff had an exclusive right to the invention before either purposely or inadvertently the defendant infringed its patent. If the constitutional and policy reasons for granting an exclusive right are important in fostering innovation in R&D, and that's a debate, but not, I'm going to assume that they are for purposes, because that's what the policy is. Why should infringement change those reasons? Put directly, why should the goal of the post-trial remedies not be to restore exclusive use? I note that while exclusive use does not necessarily imply that the patent holder has market power, it seems unlikely that there would be costly and time-consuming litigation unless in the particular circumstances, exclusive use created market power and, importantly, economic rents. That is to say, if there's been litigation and patent holder has been awarded damage, exclusive use would generally mean that the plaintiff has market power. Just let me note, and this is sort of pedantic, I understand, that there's a problem with language in this case, and particularly economists and lawyers use language differently. A firm need not be a monopolist to have market power. And it's unhelpful, I believe, to use, as the courts and lawyers frequently do, monopoly as a synonym for market power. In addition, exclusive use may or may not create market power or extreme monopoly power. I have exclusive use of my car, I have exclusive use of my home, but I have literally no market power in the market for automobiles in the state of Utah or even in the local area where I live, and very little, if any, market power in the housing market. But as I said earlier, patented technologies are valuable if there aren't good substitutes, and hence litigation is likely to occur when the exclusive use granted to the patentee does in fact create some market power. So if you start with post-trial remedies with the assumption that in addition to damages awarded at trial, the patent holder is entitled to what it had before the patent was infringed, then the court should restore the market power to the patentee. That is, to recreate what the patent owner lost. To do this, eBay has to go. In eBay, the Supreme Court overturned the Federal Circuit's decision reversing the district court's denial of a patentee's motion for an injunction following a trial in which a jury found that the plaintiff's patent was valid and had been infringed. In reversing the district court, the Federal Circuit applied what was termed the general rule that I'm quoting, the general rule that courts will issue permanent injunctions against patent infringement absent exceptional circumstances. However, at the Supreme Court, Justice Thomas, writing for the majority, concluded that the four-factor test traditionally applied when considering whether to award permanent injunctive relief to a prevailing plaintiff applied in disputes arising under the Patent Act. Making no distinctions between the types of disputes that come before the court, Justice Thomas simply set forth the four-factor test. quoting, "A plaintiff must demonstrate, one, that it has suffered irreparable harm, two, that the remedies available at law, such as monetary damages, are inadequate to compensate the injury, three, that considering the balance of hardships between the plaintiff and defendant, a remedy in equity is warranted, and four, that the public interest would not be disturbed by a permanent injunction." In a somewhat obtuse concurring opinion, Justice Roberts, joined by Justice Scalia and Ginsburg, noted that the court's opinion, quote, "rightly rests on the proposition that," then they're quoting, "a major departure from the long tradition in equity practice should not be lightly implied, and that from at least the early 19th century, courts have granted injunctive relief upon finding an infringement in the vast majority of cases. ... And while the, quote, "historical practice does not entitle a patentee to permanent injunction or justify a general rule that injunction should issue," then the final quote, "a page of history is worth a volume of logic," implying, although not saying, that injunctions should be the norm in patent matters. Chief Justice explains why. The long tradition in equity practice is not surprising given the difficulty of protecting a right to exclude through monetary remedies that allow an infringer to use an invention against the patentee's wishes, a difficulty that often implicates the first two factors of the traditional four-factor test. One wonders why it was not a dissenting opinion instead of a concurring opinion, since it's more or less a dissent. In the second concurring opinion, written by Justice Kennedy with Stevens, Souter, and Beyer, agreed that history matters, and then in a breathtaking claim asserts that the granting of injunctions, historically, almost as a matter of course, illustrates the result that the application of the four-factor test had been prevalent, but warns that in patent cases now before the courts, patentees use patents not to produce goods, but as bargaining tools to to charge exorbitant fees, engage leverage in negotiations, and so forth. All right? So you have one concurring opinion that said you really ought to turn to history, judges, and use injunctions. And you have a seventh one that says, oh, well, that's what was always going on anyway. They were using the four-factor test, and they always came up with the conclusion that it should be an injunction, which strikes me as implausible. But on its face, eBay makes no economic sense. If read literally, the first factor is backward, not forward-looking. The verb phrase is has suffered, not will suffer, and implies that injunctions are warranted only if a court decides that the amount the jury just awarded is inadequate to compensate the patent holder for the infringement that's already occurred, because what the patent suffered was irreparable. And so to right this wrong, eBay teaches that a court should confer a going forward benefit on the patent owner and a corresponding going forward burden on the infringer. Even if you read the first factor more charitably, it allows for an injunction only if there would be irreparable harm going forward. This could be irreparable harm that started with infringement, or going forward, irreparable harm that continued with the use by the defendant of the plaintiff's patent. The confusion about the purpose of an injunction is compounded by the second eBay factor. Except for irreparable harm, which by definition can't be remedied by monetary payments, it's virtually impossible to think of circumstances in which monetary payments cannot make a patent holder whole. There is no intrinsic value to a patent of the sort associated with art, a family heirloom, fondness for a person or a place, or other kinds of intangibles. Patents enable functionalities in products. Those functionalities have value because they reduce the production costs or they increase the revenues, or allow for increases in prices and quantity demanded. While determining the dollar value of these effects may be challenging, in principle, they're monetizable effects. So strictly read, it should be almost impossible for a patent holder to meet the requirements of Factor 2, and therefore almost impossible for a plaintiff to qualify for an injunction. In a sense, Factors 1 and 2 are really one factor. Was there irreparable harm, i.e. uncompensable harm, looking backward, or is there likely to be irreparable, that is, uncompensable harm going forward? What might constitute non-monetizable or irreparable harm? I can think of only two. First, if an infringer is first to market, that is able to sell a product incorporating the patented functionality before the patent owner, then there is a first mover advantage, and there is a first mover advantage in a particular commercial arena. The patent holder has lost that advantage forever. Second, if the market demand is limited in some relevant range, price range, an infringer who competes for customers that would otherwise have purchased from the patent owner could be prevented from achieving economies of scale. It's a real stretch to argue that they couldn't be monetized, but those would be difficult to monetize in those two cases, all I think not impossible. The third eBay factor makes even less sense than the first two. Remember, the third factor is considering the balance of hardships between the plaintiff and the defendant. Why should the adverse effect of an injunction on the infringer be balanced against the benefit to the patent owner? This is a bit like saying that if a neighbor builds a fence on my property, his gain from doing so should be considered when I ask the court to ask him to remove the fence. Or that someone's benefit who occupies a spare bedroom in my basement without permission should be considered when determining whether or not I can ask the court to evict him. There's a larger problem with eBay. The eBay framework clearly, if implicitly, requires that the patent owner has to demonstrate that exclusive use should be restored, rather than requiring that the infringer should demonstrate why it should be permitted to continued use of the patented technology without obtaining an arm's length license to do so. This seems to me to be very odd. Why not start with the presumption at the end of the trial, the goal should be to restore either exclusive use or the full benefit of exclusive use to the patent holder? That is, why shouldn't the presumption for post-trial remedies be an injunction, that an injunction will issue, and the infringer has a burden of proving otherwise? Is there a reason why we might want to have that proviso, that is, that the defendant and infringer has an opportunity to prove otherwise? And the answer is yes, because we're not in the same circumstances you would have been had there been no infringement. We now have products on the market that incorporate the infringing technology. Those products have incorporated scarce, valuable resources. And this is a little bit like the stranded capital problem in deregulation. We want to be careful about abandoning sort of investments that have been made in the use of resources by forcing them out. So it's possible that a defendant could argue that because of the incorporation of the patent, that they ought to be permitted to take a royalty instead of face an injunction. What would that royalty be? The answer is, in order to sort of establish the principle that you have exclusive use, that royalty would be the per unit, the profit lost by the patent owner for every unit that the infringer sells. That is, the royalty rate would be the per unitized lost profits. Greg Adams, who's in the audience here, and I once did this in a case. We were asked by an attorney, we were on the plaintiff's side, to do the lost profits, but in lieu of lost profits to have a reasonable royalty. And it wasn't reasonable royalty for things that weren't covered, weren't sold. It was a reasonable royalty if they lost on the lost profits claim. And we came back and said the lost profits should be the profits divided by the number of units, should be the per unitization of the profits. We had a hard time with our attorney. They were unwilling. He said, isn't this just lost profits in disguise? And the answer is, well, sort of, but not really, which is to say, if I'm going to unwillingly license a direct competitor, I have to get from that direct competitor what I could have earned had I sold the products. And so the only sensible royalty is a royalty equal to the recovery of the profit per unit in that case. I went through not a trial, but a deposition that was particularly nasty and focused almost solely on, aren't you just doing lost profits in disguise? I mean, isn't this just Panduit in other dress? And I said, no, I mean, you got to think about this. There was a Daubert motion, and we prevailed on the Daubert motion. So at least one judge bought the idea that this was a sensible way of thinking about reasonable royalty. So I don't think that you have to have a strict injunction, but at the very least, you can't use the reasonable royalty approach set forth by the Fed Circuit, in which you look at the incremental contribution, you look at the division of the profits, you look at the sort of negotiation, you dress it up with the Georgia Pacific factors. If you want to restore exclusivity, you have to have a royalty that reflects the profits that the patent owner would have earned had they exclusively used their patent. That's it.
All right. I appreciate that I am the last speaker on the last panel of a long day, and also that, frankly, my credentials don't stack up nearly as other presenters have today. I'm basically going to give you a litigator's perspective, some observations about current issues and trends in the litigation overlap of IP and antitrust. Some of you might have heard recently Elon Musk, who's, I mean, just a fountain of quotes, right? In the comment, and it was explained further, it wasn't just out of context, but he stated that patents are for the weak. And I could not get it out of my head as I started to prepare for this. Because, I mean, a couple notes. First of all, everyone is not in Elon Musk's situation. In fact, almost no one is. He has almost $250 billion in, I'm rounding, in personal fortune. He's got two companies that are sort of cutting edge of their respective industries, if you look at EVs and space travel. And that's not a very common scenario. But setting that aside, if you really say patents are for the weak, I think that in the case of startup companies, or who we'd call the small or medium innovators, they're simply not in the position to just go without patents and opt not to enforce them. It should be noted Tesla has a bunch of patents. They've just made the agreement is maybe too strong in my mind. The statement that they will not be enforcing them and that these are open source in a sense. He's not really legally bound to that, and that's why I don't call it an agreement. Second, I don't really see a bunch of other big companies abandoning their patents just to demonstrate that they're strong and not weak. In fact, currently IP litigation, particularly in high tech, is often a tool of entrenched market leaders to maintain or expand their market power. That's nothing new. But what might be new is there's increasingly observations that there may be a shift that's occurring from the common discussion of patents and patent litigation, how it overlaps with antitrust, which you've heard some of from the panelists here today, to the much less sexy stepsister of trade secrets, and whether those can be asserted in the same type of way as a means of expanding, maintaining, or developing market power, and whether that's something we should be concerned about. But it's unclear what the effect of that shift would necessarily be for the small to medium innovator. And I think that's often true. When we talk policy and we talk about what the intentions are to try and clean things up from an agency perspective, it doesn't always trickle down the way that's intended. A case in point might be the America Invents Act. You recall it's effective back in 2012. I don't recall the exact date. And it had multiple goals, but one of them was definitely, or two, stopping patent litigation abuse, or at least reducing it, and making it supposedly simpler to obtain and enforce valid patents. And there was this thought that this wasn't motivated by, I'm really concerned that Microsoft has not found it easy enough to enforce its patents, right? This was more about what's happening to the people who feel overwhelmed by the cost, the time, the complexity of getting and enforcing a patent. So it was passed, and it did lead to various substantive changes. But how did it play out from, again, my simple litigator's perspective? Looking at the data, cases filed since 2012, only, I found this hard to believe, but it's true, 179 patent cases actually went to jury awards. Out of those, 32 were high-tech awards that were greater than 30 million. 32. Curious, how many of those 32 high-tech awards in excess of 30 million do you think were upheld by the Federal Circuit? Anyone? One. Well, it was one. You were close with zero. One. It was the Apple v. Samsung case in 2020. The most successful high-tech plaintiffs are basically the incumbent tech giants, not the smaller medium tech companies. And that breaks, even if you take aside who prevailed, out of those 32 high-tech cases, 3 were filed by small companies. The remainder, 35%, were large companies, and over 50% were non-practicing entities. I find that very interesting too, that we're not just looking at who wins, but who's even bringing these causes of action. In short, established entities is the best way I can, because I'm not trying to say it's just the entities that have market power, but they're not, or who have monopsony, but established entities, as opposed to the person who's come up with something, they doesn't maybe have yet the ability to bring it to production. Small to medium innovators, they enforced high-tech litigation awards for them have been rare. By far, the large established entities have dominated the litigation. So I mentioned, though, that there may be a shift. I don't think it's because, as Elon claims, that more companies are deciding patents are just for the weak, but there is a rise in trade secret claims that are being brought. A couple factors that go into this. You may be aware of the Defend Trade Secrets Act that was passed in 2016, federal act. This means that you can now bring those trade secret claims in your federal court. And in fact, in 2020, 73% of all new cases, all new trade secret claims were the Federal Defend Trade Secret Act. 73%, it's pretty high, right? It doesn't mean that there weren't also state claims being brought there, but 73% had a Defend Trade Secret Act claim in there. And the sheer numbers of trade secret claims have been increasing. From 2016 to 2020, they increased from 476, I have 2021, it was 1250, so like tripling. It's a lot of trade secret claims going out there for, again, a subsection of IP that occasionally I think is overlooked because there's so much to say about patents, and yet there's a shift and it's not insignificant. Why might this be happening? There's several things. One is just the disadvantages of patent litigation. I don't think we need to harp on this very long. Patent litigation is messy, it's expensive, it's protracted, and increasingly, it can be very unpredictable. The rates of the Federal Circuit upholding verdicts are very, very low. The odds of defendants being able to invalidate a patent are significant. And so it forces companies to look at, not only might I not win this, but I might have just undercut the value of my own IP portfolio if I get a patent invalidated, or if I end up in IPR or a re-exam. I have a patent case currently that has just completed its second re-exam, brought by, of course, the same defendant. And the case has dragged out approximately 2.5 years longer than it otherwise would have, just for the stall that gets put in when that stay goes into place. That's a factor that companies have to consider. And if the cost of prosecuting and defending patents becomes too high, then you may even get to the point where there's a de facto presumption of invalidity. And that may partially account for the shift towards increasing trade secret claims. The other thing that has also been mentioned by panelists in other groups earlier today is the shifting nature of the workforce. You're seeing an increasingly mobile workforce, people who move from job to job, employer to employer, or who have multiple employers at the same time. There's also an increasing resistance to restrictive covenants, non-competes, and both on a policy side, legislatively, and just employees who are more resistant to, no, I don't know if I want to sign that. Those factors, interestingly, might cut against the ability of a company to show that it took adequate precautions to maintain the secrecy of its information, but they are also the very factors that may make it more important for them to pursue trade secret as a means of IP protection. Employers look to trade secret as the courtroom means of protecting what they might not have been able to shield from workplace access or transfer. As the second sort of shift that seems to be happening is, and this is, I will admit, probably premature to call a shift, but there are some interesting cases out there, we'll just say, that show as antitrust policies are getting renewed attention on the agency side from the administration, competitors are showing maybe some more signs of pushing back on the use of IP litigation as a market tool. The quick case that I think is interesting on this is Westlaw. Probably most of you in here have at least heard of Westlaw, even if you're not the attorney. And so in short, Westlaw has Westlaw has 80% market control. I think it's probably higher, but they will admit to 80% market control for legal research tools and a massive database of case law. The case law, and so we're talking, these are judicial opinions, regulations, statutes. There's no dispute that that's not original creative work, but Westlaw has argued and succeeded at times that some aspects of their database, such as page numbers and headnotes and such, may in fact be protectable. Regardless, they have a massive database that is incredibly hard to reproduce. Just take that at face value. They never license access to the database, so it's very difficult for competitors to find ways to improve on the search tool. No one really cares about, I don't think there's a big market demand out there for improving the page numbers in the database. It's not that. What is it people care about? The search tool. And that's always been part and parcel of it. So a company named Ross used, allegedly, artificial intelligence. And I'm simplifying the facts a little bit because there was an intermediate company, but they used artificial intelligence to mine Westlaw's database for source material to develop and use their search tool, Ross's own search tool. Westlaw sued them for copyright infringement. And Ross was out of business less than a year after the suit was initiated. But Ross doesn't give up. Ross says, you know what? It's time for counterclaims, and brings a slew of antitrust counterclaims that say, this is out of line. You are just strangling this market. Nobody else can build tools. No one can improve on your tools, which frankly aren't that good, because you won't let us have access through licensing or otherwise to the database. Okay. The court, so this was in like April of this year, actually, that Westlaw, of course, brought a motion to dismiss. The court dismissed the alleged Sherman Act violations. There was refusal to license and sham litigation, but allows tying claim to go forward. And essentially, as you can imagine, that the search tool was unlawfully tied to the database. And I found it, frankly, kind of surprising friendliness to a potential tying claim that sometimes courts have not shown. For example, the court held, and this is just on a motion to dismiss, we don't have a final, but the court held that the search tool could be a separate product from the database, even though it's not contested that it's available separately, right? Westlaw doesn't sell the search tool separately, and apparently Westlaw conceded that their search tool doesn't even work with any other database. Like, even if someone said, I really want to license your search tool to use on my database, Westlaw would say, sorry, it's actually not good for anything but ours. And the court said, yeah, but it could be separate. I can conceive of that. And what was the compelling difference to the court? My take on this, but when you read it, the court went really old school and said, previously, that database was in books. Some of you may not remember this, but there were actual books. And that's really what led to the database. And they can say page numbers, and they can say this and this. But you can't argue that when the database was essentially all in hard copy, that wasn't a separate product. So, says the court, I think it's different. I think that there's a potential tying claim here, and I'm going to allow it to go forward. My 2 cents, just me. I think this may be an instance of the court looking for a claim to fit the concern. That's kind of my way of putting it. And the concern in this case perhaps being that, okay, maybe we see a case of an entrenched market leader avoiding competition and potential innovation by limiting access to what they built but didn't necessarily innovate. And it's that idea that I think Michael said earlier, that innovation is cumulative in nature. And I think we see so much in high-tech cases, this notion that you may have done something innovative 10 years ago, But to use that to block out all future innovation really is short-sighted in terms of what we may want to encourage in competition and possibly consumer welfare, or just flat out, what do we think leads to improvements in products and services? So I think that's interesting. And it's stark contrast. I won't get into the details, but the Epic Games v. Apple suit, which I believe is scheduled for hearing by the Ninth Circuit today, interestingly enough, doesn't really have an IP aspect, has a huge antitrust aspect. But the reason that I would just bring it up is that in that case, first of all, the opinion is incredibly hard to read by the district court. I don't know if anyone has looked. It's dense. It's a little contradictory and convoluted, even if you like where the court's going. But the interesting thing there is, one takeaway that not just me, but several commentators have had, is that maybe Epic is the maker of Fortnite, a game. Whether we say Epic or Fortnite, they're the same. Maybe they weren't the sympathetic antitrust plaintiff that the court was looking for. Why? Because if you come back to, things like Jim was talking about, what's the harm to them? It turns out they've made a ton of money. Why? Because they exist cross-platforms. They can actually monetize in other ways. And even though Apple kicked them out of the App Store, and even though, they had to pay the 30% Apple tax, it turns out like they still made a ton of money, and they have a huge market share, and they're doing very well. Should that take away from whether or not, the underlying conduct was anti-competitive? In theory, no. But I think this is another example of where courts look and go with a sense of both, is there a friendliness, let's say, in the administration, in the agencies towards questioning this type of conduct? Or, should I only be looking for sort of the most extreme cases where I have not only horribly anti-competitive conduct, but a competitor that was basically crushed? And finding that link of the perfect plaintiff and the good evidence of anti-competitive conduct, because the court did find some in the Epic case, that Apple's tax was essentially not justified by what they brought to the table, that it was super competitive if you compared it to other possible platforms. We could go on, but there were several findings that if you're just kind of reading without knowing the end, you might be saying, this sounds really bad for Apple. This sounds like they're going to come out, oh, no, actually, they're okay. There's a state unfair competition claim that's still alive, but all the big antitrust stuff from the federal sense, the district court said, nah, I think they're okay. So I guess I was like, we're out of time. And I think that, so I guess we may see more competitor antitrust claims being brought. And when I say competitor claims, I mean sort of the private litigation, as opposed to waiting for the FTC or other entities to bring it. And it may be in the venue of trade secret, or it may be back in patent world. But I think you may see more friendliness to that.
Great. Well, thanks very much. We so much great content here. We're at the end of the time for this panel, and we want to be respectful. People have flights to catch this afternoon, so we don't want to go over. But thank you so much to the panelists in this presentation. And then, is it Mark or Marshall? Marshall, who's going to send us off with some final words of wisdom.
Well, I was placed into the role of giving closing remarks, and I don't want to keep you for the reasons that George just said, so I'll cut them a little bit short. 3 years ago, when we ran the 2019 conference, I gave some sort of personal statements about how I got into antitrust and how validating it was to see that conference come into existence, and the community of scholars and advocates who'd sort of grown up around it in the last couple of years. Now it's 3 years afterward. In some sense, we've had even greater success in that immediate, in the last 3 years. Some of our allies are in positions of great authority. But on the other hand, it's still the case that that power is extremely concentrated, that inflation is rampant, that workers can't make a living, that in general control is rampant in the economy. And so we still have a lot of work to do. And I wanted to take this opportunity just to say that I think we really have articulated a vision for where sort of the principles of policy and the specifics of policy need to go into the future. But this is really a 20 or 30 or 40 year process. This is not the sort of thing that happens in one political cycle or one sort of fad, one intellectual fad. And so, one of the main goals that I have in setting up this new center that's happening at the University of Utah and working with all of you going forward is to, basically see out that long march, that long process, because it's going to take a lot more work to get to the point that we live in a more just economy. So thank you all for coming. I don't know exactly where to direct you to go for the logistical purpose, which is to be transported downtown. And where is it? That's the question. Okay, the bus will leave at 5:15 from outside somewhere.
Very good. Simple way.
Thank you, everyone, for coming.